Mr. Sergeant of Arms, invite the members into the chamber and close the doors. I hereby declare the House of Representatives of the 113th General Assembly of the State of Tennessee now in session. Will the members please stand? Will the visitors in gallery please stand and remain standing through the Pledge of Allegiance? Representative Slater will serve as chaplain of the day. Representative Slater, you're recognized.
Good morning, members. As we approach a very busy next week, I suppose the scripture verse that we should be encouraged with and remember is when the Bible says to us, "Be not weary in well-doing, for in due season you shall reap if you faint not." And so these will be busy days, and so let's continue the good work on behalf of the citizens of Tennessee. Join with me, if you would, in prayer. Heavenly Father, we pause this morning to recognize the fact that you are sovereign, you are God, you are our ruler. We have been selected by our constituents, by the people of Tennessee, to represent them and to represent your truth and your justice here in the state of Tennessee. Today, as we deliberate and as we consider policy for the citizens of Tennessee, may we seek your will and your wisdom. May we remember those who have sent us here to do your work. We pray that you'll guide us and direct us throughout the day in every decision that we make. May what we do bring honor and glory to you. We pray and ask these things in Jesus' name. Amen.
Representative Slater will lead us in the Pledge of Allegiance.
Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Clerk, please take the roll.
Roll call.
Ms. Clerk, please take the roll.
Mr. Speaker, 97 members present.
Let the journal reflect Representative Terry and Hell are excused. Next order, Mr. Clerk.
Welcoming and honoring.
Welcome and honoring Representative Parkinson. You're recognized.
Thank you, Mr. Speaker. Mr. Speaker, this morning I want to welcome the Tan Suit Subcommittee to the House floor, which is a subcommittee of the Seersucker Caucus. Make them welcome, please.
Representative Freeman.
Thank you, Mr. Speaker. I've got two separate welcoming and honoring. One, I'd like to honor the Covenant school kids who are today, for the first time since the deadly shooting last year, they will be back on campus. So everybody, please keep them in your thoughts and prayers. What a tough day for them to be back on campus. They totally redid it to give it a different look and feel, but it's still going to be a challenging day. And then secondly, last week we lost a legend here in Tennessee, definitely Nashville. Bart Durham passed away at 89 years old, and who will be laid to rest this morning, and I'll actually be leaving to go to his funeral. But 40 years ago, he started a law firm that had a reach across our state. You can't pass a bus. Anyway, and I'd like a moment of silence for Bart Durham. Thank you.
Thank you. Representative McCalman.
Thank you, Mr. Speaker. Members in the gallery to my right, I have a good friend of mine and constituent from the town of Nolensville, Mr. Kevin Pataluna. If y'all would please make him feel welcome, and he's here to see that people conduct its business. Thank you.
Representative Doggett.
Thank you, Mr. Speaker. Members, I have with me today is a shadow/intern, Miss Delia Merchant. You may recognize her from her work in the 4-H She's been up here at the Capitol a time or two. You may have seen her on RFD TV last year talking about the importance of 4-H, but she's right up here in the balcony with me to my right. There she is. Help me welcome her today. Thank you for being with us.
Representative Carringer.
Thank you, Speaker. I just want to take a moment to say congratulations to Carson and Micah Burns on their 2nd anniversary. So happy anniversary.
Representative Jones.
Thank you, Mr. Speaker. I just want to recognize a solemn anniversary that 17 years ago today was the Virginia Tech mass shooting that took the lives of 32 students and faculty members at Virginia Tech. I was 11 years old, and as time goes on, as memory may fade, it's so important to recognize and remember these lives lost, and just to remember the continued need to act. So I just want to take a moment of silence as we remember the Virginia Tech mass shooting that happened 17 years ago today. Thank you.
Representative Pearson.
Thank you, Speaker. And just a few things. One, congratulations to my brother Keyshawn and his partner Rachel on their 1-year anniversary that they are celebrating. Proud of them and hope they continue to have a great time. The second thing is to thank the people who continue to show up, who continue to fight for justice, speak for justice, as it relates to gun violence, LGBTQIA rights, and just want to honor your sacrifice of time to be committed to the democratic experiment requires not just voting, but active participation. And when so many things are going wrong, you all are examples of what is right and the best of who we are and what we can be. And so thank you for being in the movement for justice. Thank you for not yielding, not bowing down, not bending during this time, and continuing to fight for all of us and for the Tennessee that we can be. Thank you, Mr. Speaker.
Representative Barrett.
Thank you, Mr. Speaker. Just wanted to make a warm welcome to constituent, longtime friend, fellow church member, Amy Whitehead in the balcony here to the right. Everybody wave and say hello to Miss Whitehead this morning.
Representative Raper.
Thank you, Mr. Speaker. And I would like to take just a moment to say that please continue prayer for Michael Hale. He is struggling badly. And I would like to do something that's a little out of order. Usually we pray for the families of deceased, which is a great thing. But this morning, I'm going to ask a moment of silence for since his family for a prayer of healing, please. Thank you. Amen.
Thank you. Welcome and honoring. Next order, Mr. Clerk.
Introduction to resolutions.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. With that, all resolutions properly filed be introduced for rule number 17 and placed on the consent calendar or referred to the appropriate standing committee.
Without objection, so ordered. Next order, Mr. Clerk.
Senate Joint Resolutions congratulatory and memorializing.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. With that, all Senate joint resolution congratulatory and memorializing and law that has to be placed on the consent calendar pursuant to rule number 17.
Without objection, so ordered. Next order, Mr. Clerk.
Resolutions lying over.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. With that, all resolutions lying over be referred to the appropriate standing committee.
Without objection, so ordered. Next order, Mr. Clerk.
Introduction to bills, Senate bills on first consideration, Senate bills on second consideration, House bills on second consideration, petitions, memorials, reports of standing committees, reports from select committees, calendars. Mr. Speaker, the House has a consent calendar.
Chairman Zachary, you're recognized.
Thank you, Mr. Speaker. It will be passed to the consent calendar on third and final consideration and keep with Rule 50.
Gentleman moves past the consent calendar, probably second. Mr. Clerk, any objections have been filed?
Mr. Speaker, no objections filed.
Anyone seeking recognition on the consent calendar? Seeing none, any objection to the question? Seeing none, we're voting on the consent calendar. All members in favor vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 92, no nays, one present, not
Having
voting.
received a constitutional majority, I declare consent calendar passed without objection. Most reconsider table. Next order, Mr. Clerk.
Mr. Speaker, the House has a regular calendar.
Call it first bill, Mr. Clerk.
House Bill 1799 by Chairman Rudd relative to county election commissions. Mr. Speaker, the Senate bill is on the desk.
Chairman Rudd, you are recognized.
Excuse me, Mr. Speaker, you are moving faster than my feet. Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1706.
Chairman Rudd moves to substitute and conform Senate Bill 1706. By seconded without objection. So ordered. Chairman Rudd.
Thank you, Mr. Speaker. I move passage of Senate Bill 1706 on third and final consideration.
Chairman Rudd moves passage of Senate Bill 1706 on third and final consideration. By second, Mr. Clerk, call First Amendment.
House Local Government Committee Amendment number 1, same as Senate Amendment number 1.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. Same as Senate Amendment 1, move to withdraw.
Chairman Crawford withdraws amendment number 1 without objection. So ordered. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. What this bill does is it completes some reforms that we've been doing. It's very simplified on voter registration. And what this does is it requires organizations who are voter registering to vote to simply register with the state. Also, it requires to avoid fraud. It requires that, excuse me. One moment, please. Excuse me. What this does is I had my folders out of order. What this does, it requires, we have several election administrators around the state that are traveling a lot and being trained by out-of-state organizations. And this simply requires administrators of county election commissions, if they're traveling out of state, to report to the state election commission that oversees them, their travel, what money is spent, and who trained them. And that is what the bill does, Mr. Speaker. With that, I renew my motion.
Chairman Rudd renews his motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker. Reading this, and thank you for clarifying, I believe that I'm supportive because of just the horror and the harm of the narrative about the 2020 election. And so I think it's important that people who are sworn to do their jobs are doing their jobs and not looking to subvert an election or destroy democracy. Would this legislation apply if a person pays for this training themselves?
Chairman Rudd.
No, this is, it requires, if you're using a grant money or county or state money and you're traveling out of state, you'd have to report your activities to the state election commission, who is directly responsible for overseeing our administrators.
Representative Pearson.
I got it. So an administrator could go out of state, spending their own resources under the authority that they have as a commissioner or as a coordinator of elections, but we wouldn't be able to track that. Is that correct?
Chairman Rudd.
That would be their personal time. That's not official business. So whatever they do on their personal time is up to them.
Hang on. Representative Pearson.
Got it. Sorry, I'm just to this point. If it is in their official capacity, say during work hours to simplify, but they were using their own money to travel, would that be something this would have authority over?
Chairman Rudd.
I'll read this part of the bill to simplify this. If an administrator of elections attends a training, seminar, or conference or other educational event related to elections, or such event is outside the state, the administrator of elections must file a form prescribed by the coordinator of elections at minimal requesting the following. They have to name the event, the location and date of the event, the identity of the person or entity conducting the event, the number of days attending, the total amount of county, state, or federal funds being used to attend the event. The administrator of elections shall file the form with the state election commission. So the way I read this is, if they're using state, federal funds or local funds, they have got to report this. It's left open as to whether they want to report their own or whether the state election commission requires that. They can already require this since they oversee the election administrators now. This is simply putting a minimal requirement of transparency for the public.
Representative Pearson.
Okay, I got you, and I have that too. Was this the amendment that was just withdrawn? Or is this the bill? I'm struggling because I see what you're saying on the Amendment 1 where it has these clarifications, and then I heard us say that this was withdrawn, so just wanted to clarify, this is the bill that we're on with these requirements that you're articulating.
Chairman Rudd.
This should be that what we're talking on was the bill that was made in committee, which was drafting code 16897. We also made the effective, that's the bill that we're working on now. That is the bill that was passed. And we were on a different track than the Senate. So this is the bill that we passed out of the House committee, and that's what we're talking on.
Representative Pearson.
And
No, go ahead.
Chairman Rudd.
The Senate has already applied this amendment.
Representative Pearson.
Okay, thank you. The last question that I have is if there's a case where an administrator is going to one of these trainings, but they pay for it themselves, and it is learned that this wasn't necessarily for the educational benefit of our elections, is there any recourse that an election commission would have, or any of us would be able to have to prevent that person from potentially administering an election?
Chairman Rudd.
I'm not sure I totally follow you, but as I've stated earlier, currently, even without this bill, the state election commission and the election commission member, both Democrat and Republican, that's over that particular area, they have the full authority to appoint the county election commissions and to hold these administrators accountable, and they have the power to remove them for cause. They can already request anything they want. This is simply, we're requiring this so the public has full access in the event that the state election commission does not ask for this. This is the minimum that we're asking for, so the public will be able to know at their meetings.
Representative Pearson.
Okay, thank you, Speaker. Thank you, sponsor, for answering the questions.
Representative Hardaway.
Thank you, Speaker. And it was kind of a little noisy. You may have addressed some of this. On the issue of when the administrator has to inform the commission, is that before or after attending the event?
Chairman Rudd.
Afterwards.
Representative Hardaway.
And is there language which speaks to approval or just informing?
Chairman Rudd.
There is no approval. They're free to be authorized by their county election commission to go to any event that they choose or on their own. They just have to report their activities. There is no approval.
Representative Hardaway.
And the information that's collected is displayed online, or is it by request?
Chairman Rudd.
No, the former bill originally had it that they would have to report this on the county website. That is no longer required. They just have to report it to the state election commission. They would then discuss this at their state meetings or quarterly meetings, and it would be in their minutes for public access.
Representative Hardaway.
All right, and my last question is in reference to the criteria that the election commission, either the county or the state, would use in evaluating the meeting, the seminar, etc. What is that, and will there be some type of opinion offered by either one of those bodies?
Chairman Rudd.
The legislation does not require opinion or comments or to judge the event. That is within the purview of the state election commission now, and it will continue to be. But this particular piece of legislation does not require that or address that.
Representative Hardaway.
All right, thank you very much. Thank you, Speaker.
Representative Warner.
Thank you, Mr. Speaker. I move previous question.
Previous question's been called. Any objection? Seeing none, we're voting. All those in favor of Senate Bill 1706, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 78, 18 nays.
Senate Bill 1706, having received constitutional majority, I hereby declare passed without objection. Most reconsider table. Call the next bill, Mr. Clerk.
House Bill 1955 by Chairman Rudd relative to voter registration. Mr. Speaker, the Senate bill is on the desk.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. I move passage of HB 1955 on third and final consideration.
Chairman Rudd.
Excuse me, that's not in here. I move to substitute and conform to Senate Bill
2586.
2586.
Chairman Rudd moves substitute and conform to Senate Bill 2586. By second without objection. So ordered. Chairman Rudd.
Thank you, Mr. Speaker. I move on final. I move just a moment since it's not in my script here. I move on third. I'm going to my other bill. Mr. Speaker, I move to substitute and conform. Let's see, Mr. Speaker, I move to passage of Senate Bill
2586.
2586 on third and final consideration.
Chairman Rudd moves passage of Senate Bill 2586 on third and final consideration. By second, Mr. Clerk, call the First Amendment.
House Local Government Committee Amendment number 1.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. I move to adopt and defer to the sponsor for further explanation.
Chairman Crawford moves adoption of Committee Amendment number 1. Probably seconded. Any discussion on the amendment? Seeing none. All those in favor of Committee Amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopt the next amendment, Mr. Clerk.
House Amendment 2 by Chairman Rudd. Mr. Speaker, it was timely filed.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. What this bill does is this is the final kind of piece of the puzzle that we've been working on the last few years. This is to address voter registration fraud and the abuse of senior citizens. And what this does is it does three things. Number one, it states that if any organization is going to register people to vote in a registration drive, they're free to do so, but they just need to register. They don't have to go through training or pay anything. They just need to register with the Secretary of State's office that they're going to be doing so. So we know this is being conducted and make sure all the rules are abided by. Also, it states that these organizations cannot fill out the voter registration forms for people. They have to fill it out themselves. This voter registration forms, of course, contains people's social security numbers and other information that could be used for fraud. So once they assist people in voter registration, if necessary, they have to mail it back in or turn it back in themselves, the voter. And also it prohibits felons that have been convicted, only felons that have been convicted of aggravated perjury and the abuse or fraud of senior citizens. They cannot handle these voter registration forms. The last thing we need is someone who's been convicted of voter fraud, perjury, or abuse of a senior citizen is having senior citizens' social security numbers. I can't read that. I renew.
Chairman Rudd, you move adoption of your amendment number 2? Can I get you to move adoption amendment?
Sorry, I don't have a script up here, so I'm flying blind. I move adoption of amendment 2.
Chairman Rudd moves adoption of amendment number 2. Probably seconded. Any discussion on the amendment? Seeing none. Any objection to the question? Seeing none, we're voting on the board. All those in favor of adopting amendment number 2, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Aye, 68, 22 nays.
Amendment number 2 is adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Rudd, you are recognized.
Thank you, Mr. Speaker. I have explained the heart of the bill, and the only thing remaining is there is a penalty for violations of $5,000. Other states that have passed similar legislation have $50,000 fine. I felt that was too excessive, so I lowered it substantially. With that, Mr. Speaker, I renew my motion.
Chairman Rudd renews his motion. Any discussion on the bill? Representative Miller, you are recognized.
Thank you, Mr. Speaker. Sponsor yield. Thank you, Mr. Chairman. I voted against the bill in committee. Just to kind of go over it as much as we can again, it requires a 2/3 party voter registration organization to register and provide certain information to the coordinator of the election before engaging in a voter registration event or program. Let me ask you the question, why do you think these third-party voter registrators, what is their purpose? What is their actual purpose?
Chairman Rudd.
You'd have to ask them. I would assume they're registering people to vote.
Representative Miller.
I would think that would be an accurate, good answer. They're actually out there to register people to vote. But based on this legislation, it seems as if what it will do is prohibit and limit and restrict them from actually going out and registering people to vote. But that's exactly what their purpose is, to go out there, to participate in the process. Do you think this is some type of business for profit, these third-party organizations?
Chairman Rudd.
I have no idea whether they're profitable or whether they're non-profitable. That's never occurred to me. I just want voter registration, and this does not restrict voter registration except the use, a narrow definition of felons who have been convicted of abuse of seniors. There is no harm in anyone registering, just so we know that they're organizing. Outside of them registering their organization that they're going to be voter registration, it doesn't put limits on them except they can involve felons, and that they cannot pre-fill the forms out, which to me would be logical since that's where fraud would come from.
Representative Miller.
So based on your study, your research, could you give us some examples of how much actual fraud that's being committed in reference to voter registration drives in this state?
Chairman Rudd.
In the past, organizations, both in-state and out-of-state, but especially out-of-state, but they both occurred both in-state and out-state, they have paid people, which is not prohibited, they have paid people to go out and register people to vote, which is fine. But what they do, they get paid per form turned in. So their motivation, a lot of these workers are to not necessarily even the organization, but the workers are to turn in as many forms as possible so they get paid. The forms aren't checked. They're not properly filled out. Many of them have fictitious addresses, fictitious names. They're improperly done. It takes a lot of time and it takes a lot of energy for the county election commissions to go through all these and throw them out or call and verify if they're proper. So this is simply requiring them to register so we know who's doing it. And that's all. That's really the main focus of this. And that's the really, other than the other limitation I told you on felons, and they can't pre-fill the forms out. That's the only two real limitations it is. I can't believe that any organization, no matter how small or how large, in-state or out-of-state, is not willing simply to go online and register that they're going to be conducting a voter registration drive. That's all that they're requiring them to do, to go online and tell us that they're doing it. That doesn't restrict people or prohibit people from doing it. And I can't imagine if anyone is going to be obeying the law and has no ill intentions, that they wouldn't mind letting us know what they're doing.
Representative Miller.
So currently you're saying that the coordinator of elections does not have a listing of these third-party registration organizations?
Chairman Rudd.
Right now, they're not registered. We don't know what they're doing unless the county election commission of their own demise, their own initiative gets their names when they pick forms up. They also may now, if anyone picks up large amounts of forms from the state election commission, they're going to have to sign for the forms. So they'll know at that point they pick forms up, and that's under existing law. This doesn't address that.
Representative Miller.
You currently know of personally, any of these third-party organizations and registration organizations? Do you know of any?
Chairman Rudd.
Know of any what?
Representative Miller.
Third-party registration organizations.
Chairman Rudd.
I mean, you just want, you're asking, do I know any of their names or do I know any of their activities?
Representative Miller.
Organizations, you said they are third-party registration organizations. Do you know of any of these organizations that are operating, let's say, in your district?
Chairman Rudd.
In my district, they probably are operating. I don't know what's operating in my district. My county election commission hasn't reported any organizations committing errors that I'm aware of. There are organizations that are on campus, off campus, out of state, in state. They mainly operate in larger cities and larger counties. There's usually not enough people or new residents to register in rural counties or smaller counties for organizations to bother. It could be, I don't know, it could be the League of Women Voters. It could be the National Voter Alliance. It could be all kinds of organizations that are registering. I don't really keep up with those. And I don't care whether they're left wing, right wing, independent, anything, as long as they obey the law and don't violate our senior citizens' rights, they're free to operate in Tennessee.
That was the 5. Representative McKenzie, you're recognized.
Thank you, Mr. Chair. I too am in local government committee, and I remember we took a fairly rough voice vote on making this, and am I correct in we changed the date from an effective date of after the election to be effective upon the governor's signature or before this primary and general election. Is that true?
Chairman Rudd.
Clear.
It's effective becoming law.
Representative McKenzie.
Thank you for that. Isn't that extremely problematic because you got this new thing coming now that no one knows about, unless the folks listening to this session right now. Isn't that going to be problematic on getting the word out on what all these new restrictions are and rules are and fines are? Isn't that going to be very hastily done and restrictive on our citizens?
Chairman Rudd.
I do not perceive so, no.
Representative McKenzie.
Well, I'm going to politely disagree with you on that one because you're talking about an extreme third party, out of state, radical on one side or the other, but most of the people, they're local organizations. They're people that are really trying to get us engaged. Did you know that the last election, we were 50th? We were the worst state on voter turnout and participation. We're number 50. That's not an aim that we're trying to get to. So we're at number 50, and then we're continuing to introduce these pieces of legislation that make it harder and more punitive for honest mistakes. And that's what we talked about in committee. Honest mistakes yield the same thing as some operative coming from, I don't know, third world country in here to try to poison our elections. I don't know where they're coming from, but don't you agree that we should do better and try to open up the pipeline to allow more of our citizens and constituents to be educated and informed on how to vote?
Chairman Rudd.
No, right now, if you're saying that we need to do nothing and to make it continue to make it too easy for organizations to break the law, to employ felons, to get a hold of senior citizens' privileged information, that fill out forms and don't turn the forms in, that turn in improper forms, etc. We allow that type of fraud, and whether it's by honest mistakes or on purpose to continue, we're doing a disservice to our citizens.
Representative McKenzie.
That's not what I said. But again, there's nothing in here, and I said this in committee, knowingly and willfully. If you'd have added those two, I get it. If someone is intentionally trying to break the law, I get it. If someone intentionally is trying to abuse our elders, let's go after them. But don't put words in there that don't belong. Knowingly and willfully are great words that should have been in this bill. But if I'm with a local organization just trying to get my college students to attend and I make an honest mistake, it's the same penalty as someone who knowingly and willfully does that. And it's not happening. So my last question to you is, how are we going to enforce these? Are we going to ask the state agency to go and monitor these? Are we going to put additional tasks? Because these things are already against the law for the most part. Are we going to put additional taskings on our election commissions to go out and monitor these? So what exactly do you think the mechanics are going to be after this becomes law to catch these kids and unsuspecting people who are simply trying to get more politically active?
Chairman Rudd.
I don't know about kids, but like any new law, once something's implemented, there's always a lot of leniency the first year of implementation, a lot of a learning curve on any new law. That's one of the reasons the coordinator of elections wanted to move this up, so he has time to work with these organizations and inform it. We can't work with them if they're not conducting the actual event in question. So I think that between they can't print their own voter registration forms. Any of these drives, they're going to have to pick the forms up. Once they pick the forms up from either the state or county, they'll inform them of the law at that point. So there shouldn't be any excuse for not knowing. And like I said, I'm sure as any law, when it's first implemented, they'll be lenient and give them a warning and try to work with them.
Representative Hardaway.
Thank you, Speaker. And to the sponsor, just a few questions for clarification. Is there at any point within the amended bill a requirement for the county election commission or the state election commission to contact the applicant?
Chairman Rudd.
I guess I'm not really following you, what you're implying. You're talking about, is it in the bill that the county election commission has to contact the organization?
Representative Hardaway.
No, sir. The applicant, the voter that actually, the prospective voter that filled out the form.
Chairman Rudd.
What would they need to? I'm still not following you. What would they need to contact the voter, the newly registered voter, for?
Representative Hardaway.
I can think of none, and that's why I wanted to ask you to make sure that there's nothing in here that requires it.
Chairman Rudd.
No, under current state rules and laws, procedures, that if a voter registration form is turned in to the county election commission and they notice an error on it, they at that point try to track down the voter to see if they're in fact are the one who filled the form out. And if there's a slight typo on it or mistake in the address or their spelling of their name, they will correct that when they contact them. If they can't find them, if they don't know who they are, then they will never be registered and it will be held back. And that'll be discovered at a later date when that individual tries to vote.
Representative Hardaway.
All right, thank you. And is there any reference in here to existing penalties? I'm aware of the fines that are listed, but is there any reference to other existing penalties that are already in statute?
Chairman Rudd.
I don't know that any of these are addressed currently, but we have very limited actual both criminal penalties and actions taken on voter registration fraud. That's why we're passing this, to make sure that that's corrected in the law.
Representative Hardaway.
Thank you. And we had a young lady, Pamela Moses, that took the opinion from a government agency, TDOC in particular, and was still convicted for violating the law. Is an opinion from a local election commission or a state election commission, is that a defense for any of the offenses listed?
Chairman Rudd.
I'm not sure I'm totally following you. Of course, if you're talking about criminal prosecution of committing fraud on a government document, which is already in law, this doesn't go there. That would be up to the local DA whether they're prosecuting that. That is not really totally addressed here. what is addressed here is if you violate the 3 points really that are in this bill, at that point you would have a fine or a fraud implemented by the coordinator of elections, and if necessary, it would be through also the local DA.
Representative Hardaway.
All right, specifically, can any of these fines be defended? Can the defense to these fines be that I got the opinion from a local election commission or a state election commission?
Chairman Rudd.
I guess I'm having trouble following what you're kind of going outside. You're going outside the bill a little bit. A lot of the rules that you're talking about are already in place as far as empowering the state election commission and the powers of the office of the coordinator of elections. So this is kind of going a little bit beyond the bill itself.
Representative Hardaway.
Okay, I'm having difficulty in, I guess, in communicating on this, trying to see past Faison's eclipse. So on the severability clause, is that in the amended bill or not?
Chairman Rudd.
Yes, the amendment was a severability clause. That's in the event that there's some lawsuit and a judge should overturn any, which is normal for most election bills, but we left out of this one originally that if for some part of this bill were to be upheld, the rest of it would be implemented rather than the whole bill turned down. And this bill is carefully crafted after recent federal court opinions, and everything in this bill has upheld federal court appeals and judgments recently this year.
Representative Mitchell.
Yeah, thank you, Mr. Speaker. Sponsor, on this, so if someone, the group or person fills out all the information on it, on a voter registration or maybe on a candidate petition, would you see it as the duty, let's say they even forged the name, would you say it was the duty of the administrator of elections of that county to report that to the DA?
Chairman Rudd.
I would say at that point, which would happen currently, if you were to forge a voter registration form or any government document, that is a commission of fraud in itself, and that could be reported to the local DA. I would imagine if a local administrator or any other local government official found that, they would first check within their department. They'd probably check to the state, whether it be like if it was regular government, to the comptroller and ask questions. In this case, it would be the coordinator of elections. They would recommend what action to take and what procedures to take at that point if it need to be further investigated.
Representative Mitchell.
So it would be the duty, even if the coordinator of elections knew it as well, it would be his duty as well?
Chairman Rudd.
Well, it's the duty of any appointed or elected official or anyone in Tennessee. If you know that a law has been violated, it's your duty under state law currently, I believe, to report that to the authorities.
Representative Mitchell.
I appreciate it. Thank you.
Representative Zachary.
Thank you, Mr. Speaker. My previous question.
Previous question been called. Is there objection? There's objection. All those in favor of previous question vote aye when the bell rings. Those opposed vote no. As every member voted, does any member wish to change their vote? Lafferty, aye. Mr. Clerk, take the vote.
Aye, 72, 22 nays.
Previous question prevails. We're voting. All those in favor of Senate Bill 2586 as amended, Senate Bill 2586 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Aye, 73, 23 nays.
Senate Bill 2586, having received a constitutional majority, hereby declare passed without objection. Motion considered table. Let the journal reflect. Representative Freeman is excused. Chairman Rudd, for what purpose?
Wanted to address the assembly. For
Call up next bill, Mr. Clerk.
House Bill 2404 by Representative Slater, relative to dependent and neglected children. Mr. Speaker, the Senate bill is on the desk.
Representative Slater, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2349.
Representative Slater moves to substitute and form Senate Bill 2349, probably seconded without objection. So ordered. Representative Slater.
Thank you, Mr. Speaker. I move passage of Senate Bill 2349 on third and final consideration.
Representative Slater moves passage of Senate Bill 2349 on third and final consideration, probably seconded. Mr. Clerk, call up First Amendment.
House Civil Justice Committee Amendment number 1, same as Senate Amendment number 1.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Slater, you're recognized.
Thank you, Mr. Speaker. As amended, this bill modifies one point in the definition of dependency and neglect. The change in definition would underscore that dependency and neglect begins at the point a case is filed, not at the time the case is decided. And with that, I renew my motion.
Representative Slater renews his motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker and sponsor. Just for clarity, there hadn't been a decision made yet about the child neglect that may have occurred, and already we would be sort of penalizing the family. Just could you articulate that a little bit further?
Representative Slater.
Thank you, Mr. Speaker, and thank you for the question. When a juvenile comes before a juvenile court judge, at this point, the first time they come before the judge, they're probably in one of three different situations. They're either in DCS custody, they're in foster care, or they are in relative care. And so when they come, the circumstances of them being in that care, out of their home, in that care, are already before the juvenile court judge. And so it's in the best interest of the child, according to my juvenile court judge, who also consulted perhaps with yours as well, and with many juvenile court judges, it's in the best interest of the child for that determination of dependency and neglect to be determined at that point.
Representative Pearson.
Thank you. How would it be determined with, so I appreciate that. I just want to make sure there's like fact finding, there's data, there's resources that would confirm that outside of just a judge's determination, just in sort of that moment because the case is before them. And so how is that typically, from what you know, decided without there being sort of more inputs or more information?
Representative Slater.
Thank you, Mr. Speaker. And I'll just give you one illustration, though I've been given several illustrations. These are not hypothetical. So what I'm going to give to you is, in fact, a case that took place. As you know, there's often a period of time between that first appearance between the juvenile court judge and final adjudication. When dependency and neglect is attached later instead of sooner, sometimes the circumstances change. So very quickly, one of the illustrations that was given to me is that there was a juvenile who was in the home of his grandmother. The father was also very engaged and was not a part of the dependency and neglect. The mother was. She moved out of state during this period of time. The father passed away. She came back, and then she did not, at that point, because dependency and neglect had not been assigned sooner rather than later, she now stood in a position where the circumstances had changed. And so in that circumstance, and in others as well, I only share that one with you, this would have been for the benefit of the child.
Representative Pearson.
Thank you, Speaker, and thank you for answering the questions thoroughly and thoughtfully, sponsor.
Any further discussion? See none. Any object? You sure? No objections to the question. We're voting. All those in favor of Senate Bill 2349 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 85, 3 nays, 4 present, unvoted.
Senate Bill 2349 having received constitutional majority, I hereby declare passed without objection. Most reconsider table. Call up next bill, Mr. Clerk.
House Bill 2466 by Representative Stevens, relative to expunction.
Representative Stevens, you are recognized.
Thank you, Mr. Speaker. I move passage of House Bill 2466 on third and final consideration.
Representative Stevens moves passage. Probably second. Ms. Clerk, call First Amendment.
House Criminal Justice Committee Amendment Number 1.
Chairman Holsey, you're recognized.
Thank you, Mr. Speaker. Move to adopt and defer to sponsor for explanation.
Chairman Holsey moves adoption of Committee Amendment Number 1. Probably seconded. Any discussion on the amendment? Seeing none. Any objections to the question? Seeing none. All those in favor of Committee Amendment Number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Stevens, you're recognized.
Thank you, Mr. Speaker. This bill does two things. First, it authorizes a court to release a petitioner's copy of an order of expunction to the petitioner. And second, it authorizes the TBI to inform a district attorney general for a judicial district if a petitioner has been granted a prior expunction. And with that, I renew my motion.
Representative Stevens renews his motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker and sponsor. Related to this, I understand and appreciate the petitioner being able to get access to their file. I have questions sort of about this district attorney part because the current law under TCA 38-6-118 does articulate that when a judge, district attorney general, defendant, or defendant's counsel requests a certificate from the Bureau, TBI, relative to a defendant's eligibility for pretrial diversion pursuant to Title 40, Chapter 15, the Bureau shall conduct a criminal history record check based upon the defendant's name, date of birth, social security number to determine if the defendant A, has a prior felony or Class A misdemeanor conviction, or B, has ever previously been granted a type of diversion, or I'm assuming in this case as it relates to expunction. Can you explain why sort of this new standard related to DA's accessibility is different from what's under current law and its implications?
Representative Stevens.
Thank you, Mr. Speaker. First off, let me clarify that in Tennessee, the policy is you get one expunction during your lifetime. And the way that the law is now, you're talking about pretrial diversion, which is different from expunction. Diversion is part of your sentence. Expunction is when your record is removed and cleared from your name. So you get one expunction during your lifetime. If you have a criminal who has charges in 2 different districts and he gets one of the charges expunged in District 1, the district attorney in District 2 may not know that he's used the expunction already. So this would allow the TBI to let other district attorneys know if someone's already used an expunction.
Representative Pearson.
Thank you. And I appreciate sort of the clarification here. It's under current law that we would only allow one expunction? Is that what you said?
Representative Stevens.
That is correct. You get one expunction during your lifetime.
Representative Pearson.
And this law would make it so that if a person were to, and expunctions come after people have served their time, paid off all the debts as it's related to court costs and things like that. That's correct?
Representative Stevens.
You are correct. This is a very, very small loophole where people have been able to get multiple expunctions when they're only supposed to get one. And this just closes that loophole so with the TBI can tell other district attorneys if someone has used an expunction before. That's all it does.
Representative Pearson.
Thank you, Speaker and sponsor. I understand that maybe it's a big policy difference that I think we should have, because I think if people have sort of served their time and done all the other requirements, that we should be willing to have grace as it relates to them. But your legislation is going to address that larger issue, but that's concerning to me. And so for those reasons, I understand the loophole you're trying to close, the grace loophole, if you will. But I do think it's important for us as a state probably reconsider how we ensure that people who have served their time and have done their due diligence are able to be full members of our society. Thank you for answering the questions, and thank you, Speaker.
Representative Warner.
Thank you, Mr. Speaker. I move previous question.
Previous question being called. Is there objection? Seeing none, we're voting. All those in favor, House Bill 2466 has been to vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk. Ms. Clerk, please take the vote.
Ayes 96 nays.
House Bill 2466 having received constitutional majority, everybody declare passed without objection. Motion to consider table. Call next bill, Mr. Clerk.
House Bill 1719 by Representative Gillespie and others relative to bail. Mr. Speaker, the Senate bill is on the desk.
Representative Gillespie, you're recognized.
Thank you, Mr. Speaker. I move to substitute form to Senate Bill 2565.
Representative Gillespie moves substitute form Senate Bill 2565. Probably second without objection. So ordered. Representative Gillespie.
Thank you, Mr. Speaker. I move passage of Senate Bill 2565 on third and final consideration.
Representative Gillespie moves passage of Senate Bill 2565 on third and final consideration by second. Mr. Clerk, call First Amendment.
House Criminal Justice Committee Amendment number 1. Mr. Speaker, it's the same as Senate Amendment number 1.
Gentleman Holsey, you're recognized.
Thank you, Mr. Speaker. Same as Senate Amendment 1. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Amendment 2 by Representative Pearson, Mr. Speaker, was timely filed.
Representative Pearson, you're recognized.
Thank you so much, Speaker and colleagues. Look, I am deeply concerned about this legislation and its implications as it relates to wealth-based discrimination. I ask that each of you support this amendment, which is intended to, if there's a way, improve this legislation. We cannot continue to use bail as a precursor to dealing with the issues of gun violence or the issues of crime in our communities and ignore the root causes of the problems that we are seeking to address. And so I really encourage each of you who understand our Constitution, who don't want to pass something that's anti-constitutional, such as this legislation, to support this amendment to this legislation. I understand the concerns that people have had as it relates to bail. Our entire county, I see a couple of our representatives, our entire county has had to reform our bail system. The process is working. I've talked to a lot of advocates who are seeing improvements. And are there going to be challenges? Certainly. But I think that it is anti-constitutional, this legislation, and the amendment reads this way. We're deleting the language and financial condition and substituting and financial condition, including the defendant's ability to pay. The Eighth Amendment of the United States Constitution and Article 1, Section 15 and 16 of the Tennessee Constitution requires all prisoners to be bailable except capital offenses and prohibits excessive bail. Understanding cash bail is a part of that. It's one of the things that our magistrates consider, and removing that is actually anti our own Constitution. You can use a lot of stories and have a lot of qualitative data, which is data in and of itself, but doing things that go against the very institutions of our constitutional democratic republic is wrong. And this legislation does that. And so this would enshrine and further support what we know to be already in our Constitution that the founders of this state recognized was important. And I don't think this legislation is more important than the core of our own Constitution. And so with that, Mr. Speaker, I move for adoption.
Representative Pearson moves adoption of amendment number 2, probably seconded. Any discussion on the amendment? Leader Lambert, you're recognized.
Previous question on the amendment.
Question's been called on the amendment. Any objection? Seeing none, we're voting on the amendment. All those in favor of adopting amendment number 2, vote aye when the bell rings. Those opposed, vote no. As every member voted, does anyone wish to change their vote? Mr. Clerk, please take the vote.
Ayes 22, 72 nays.
Amendment number 2 fails. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Gillespie, you're recognized.
Thank you, Mr. Speaker. What this bill does would allow the current practice of considering a defendant's ability to pay when setting bail. Currently, judges are using an ability to pay calculator, which basically allows bail to be set based on the amount of money immediately available to the defendant and not the threat to the community, the severity of the crime, or the defendant's likelihood of showing up for court, but how much money they have in their pocket at the time. With that, I renew my motion.
Representative Gillespie renews his motion. Any discussion on the bill? Representative Pearson, you're recognized.
Thank you, Speaker. And sponsor, if an individual is wealthy and they go before the magistrate and say they're a billionaire and they're given a bail of $1 million, is that different than a person who is unemployed and is given a bail of $1 million?
Representative Gillespie.
Thank you, Mr. Speaker. I believe that you should be treated the exact same for the crime that you're accused of. Bottom line. Bond is to be determined by how dangerous the person is and the likelihood of them coming to the court and nothing else.
Representative Pearson.
Thank you. And there are several considerations that magistrates look at, including folks' ability to pay when making these determinations, including the safety of the community. but your legislation is seeking to prioritize the taking away of an individual's liberty and its connection to their ability to pay for bail as part of sort of your attempt to address crime or other problems. Is that correct?
Representative Gillespie.
No, that is incorrect.
Representative Pearson.
Thank you. What I think this legislation is about, and based on what I have seen and the arguments that have come up in the committee about this legislation and everything that I've heard, is you are supporting wealth-based detention. That if you are poor and possibly innocent, you get treated worse than people, as Brian Stevenson would say, are rich but guilty. Enshrining and codifying legislation that hurts poor people is immoral. Codifying legislation that we know is going to have a discriminatory impact, especially on people in our county, in Shelby County, is wrong and it is unjust. There aren't any, as far as I know, commissioners or folks in our county that are asking for this type of legislation. You are doing this in part, and it's a political game for a lot of people, but this is really having implications that are negatively targeted at people who are poor and low income. The ability to pay is one of several considerations that a judge should look at because it matters to who ultimately is being granted their liberty. And what you are articulating with this legislation is that richer people and wealthier people have more of a right to their liberty than poor folks who also could be proven innocent or not guilty when things are adjudicated. This is bad legislating. This is bad policy. This is targeted. This is wrong. This is immoral, and this is unjust. And this is not something that is going to help or benefit Shelby County. This, again, is the type of legislating that comes out of the hypocrisy about local governments being able to govern themselves in some cases, and then government overreach every time you come up here to Nashville and to the General Assembly. We have a responsibility to do everything that is in the best interest of our community. And Shelby County is working very hard and very diligently on the problem of bail, on the problem of criminality, on these issues. And this legislation is only setting us further back. It is so important that we always have, and this comes from folks doing good work at Just City, you want judges to look at all information as it relates to a person who is before them in connection to pretrial release. They need to look at all information, but it is not fair to tell a poor person that they have to pay as much money as a very wealthy person can pay without any consideration of their financial status. What you're doing is creating, again, very, very apparently two justice systems, one for rich white folk and one for poor black folk. And that type of legislating that has happened over centuries, let's just be honest, is very, very harmful. And there's not case law in our state to support this. And I'm sure you're familiar with this case, Rodriguez v. Providence in the state of Tennessee in 2015, or Torres v. Collins in the state of Tennessee in 2020, where the courts said that the injunction also prohibited the use of present secured money bonds, defined as bonds imposed without a hearing on or inquiry into the probationer's ability to pay the bond. The Tennessee Bar Association says the Tennessee Constitution guarantees all prisoners shall be bailable by sufficient sureties unless for capital offenses. This is an anti-constitutional, targeted, and wrongful piece of legislation. It is not helpful to Shelby County. It is not helpful to the issues of criminality, and it is wrong.
Representative Gillespie.
Thank you, Mr. Speaker. I would say that there is one system of justice, and this is ensuring that I think to the previous speaker, my colleague from Shelby County, we're just going to agree to disagree on this issue, that I'm trying to make our community safer, and this is the way that I'm doing it. And with that, Mr. Speaker, I renew my motion.
Representative Ritchie.
Thank you, Mr. Speaker. Mr. Speaker, I request to be rolled one space.
Without objection. All right. Representative Jones, you're recognized.
Thank you, Mr. Speaker. First of all, to the sponsor, this bill is not about increasing public safety. It's about keeping poor people in jail. A recent study by the Sycamore Institute found that Tennessee's pretrial detainee population grew 40% from 1991 to 2018. It is the fastest growing pretrial detention population in the nation. Representative Gillespie, have we become a safer state in that time?
Representative Gillespie.
Thank you, Mr. Speaker. I'm sorry. Can you repeat that? I didn't hear a question there.
Representative Jones.
A recent study by the Sycamore Institute shows that Tennessee's pretrial detainee population grew 40% from 1991 to 2018. It is the fastest in the nation, the fastest growing pretrial detainee program in the nation. Have we become safer in that time?
Representative Gillespie.
Thank you, Mr. Speaker. I would say that my community has not become safer in that time, or specifically has not become safer since this system that Shelby County has set up in the last 2 years. No, we have not become safer. And that is what I'm working to do to change that, to make my community safer. Furthermore, I would state that I cannot tell you how many situations in the past 2 years where there's been a defendant that has been accused of another more violent crime that if you go back and look at why they were out on the street to begin with, it is because of this situation right here that we are talking about. And that is what I'm trying to address. So to answer your question, no, we have not.
Representative Jones.
Thank you. So keeping poor people in jail, as your legislation is intending to do, does not make our community safer, Representative Gillespie. Furthermore, we look at the 8th Amendment of the U.S. Constitution, Article 1, Section 15 of the Tennessee Constitution, which prohibits excessive bail. How do you determine if bail is excessive or unreasonable if you don't consider the defendant's financial condition? Can you explain how can we even determine that if we're not looking at financial conditions, if bail is excessive or not?
Representative Gillespie.
Thank you. You would still be able to take into the financial consideration, just not the ability to pay.
Representative Jones.
Representative Gillespie, I know they have you up here presenting this bill. It's not good. It's not good for the people of our state. It is a cruel bill. And we love to talk about religiosity in this building. There's a scripture that says, when I was in jail, did you come visit me? Not did you keep me in jail by keeping me in poverty and having a separate justice system for people like Donald Trump who can pay for his bail. He was in court this week, and regular folks who can't afford excessive hundreds of $1,000s, $1 million bail. And so the thing about our justice system, Representative Gillespie, you have a lawyer next to you, I hope he knows this, is that in our system of justice, you're presumed innocent until found guilty in court. And so you're going to be keeping people in jail, many of whom could be innocent, and saying that because you're poor, you have to stay in jail. That is cruel. That is unjust. That is immoral. That is shameful. That is not something I would want to put my name on. Don't have them up here making you be the cheerleader for this foolishness, Representative Gillespie. This bill will not increase public safety, but let me tell you a little bit about what it will do, is that this will increase budgets. It will increase and exacerbate the issue of overcrowded jails in our state. It will increase lawsuits because people are going to be forced into jail and left there in systems in which we already are seeing understaffing. We're not seeing adequate care and concern for those who are in our jails. We're having lawsuit after lawsuit against jails where people are being mistreated and not being treated like human beings. These are people who are presumed innocent. And so my question, because your friend is up there, Representative Lambert, is that how does this system embrace that notion of our justice system that people, this proposal, are to be presumed innocent until proven guilty in the court of law by unreasonable doubt? How does this system of keeping poor people in jail continue to uphold that principle of presumption of innocence? And is it wrong, in your opinion, to target poor people under the guise of saying that because you cannot afford to pay, because you are working class or poor Tennessean, that you are to be treated separate and unequal from those who are wealthy, who this legislature time after time serves? That is a deeply concerning part. And finally, my third question, since we have a whole team up here to answer questions, is how will this address the issue of overcrowding in our jails? Will this not increase the overcrowding in our jails that is already an issue in many of our counties? And how can we address that to the team assembled to answer these questions? Thank you.
Lear Lambert.
By the way, I love the assumptions. The team that's up here is standing here to show our support for this particular piece of legislation. If you have questions, I'll be happy to answer those as I am right now. Under the Eighth Amendment, you can't take into account ability to pay, period. In my belief, you've asked my opinion on this, it is unconstitutional to take into account someone's ability to pay. That's nowhere in the Eighth Amendment. It is a reasonable bail that you are guaranteed. Bail is there for two reasons, two silos. That's all we're talking about. Safety of the community. How dangerous is that individual? How often have they been arrested? Now, you may be perfectly fine with folks running the streets that have got 50 prior convictions and have committed another violent felony and just let them out to do it again and again and again and kill police officers and rape individuals into the community and do every other type of crime. But this representative is proposing a bill that says, look, let's look at dangerousness of that individual. How dangerous are they in the community? And oh, by the way, are they going to show up or not? That's it. It's those two things. Every single person that is arrested, every single person that a bail is set for, there's a absolute guarantee that they are innocent until proven guilty. However, a magistrate has looked at the facts of that case and said there is probable cause that they have committed a crime. We cannot just ignore the fact that a magistrate has looked at the facts of the case at that juncture and said there's probable cause. Now, you may not like that fact, but it is an absolute fact that there has been a judicial determination that there's probable cause that a crime has been committed. So why would we not then look at the criminogenic factors that have led that individual into the courtroom again? Are they a first-time offender? Is it a crime that there's probable cause for that is a theft crime or a low-risk crime? Or is it murder? Is it rape? Is it robbery? Is it a very dangerous crime? And again, there's probable cause that has been found on. Oh, by the way, has that person failed to appear in court 5, 6, 7, 8, 10 times? Is there a likelihood that they're actually going to come and face their charges? If they've appeared in court every single time that they've ever had a charge, sometimes that lengthy criminal history can show that they will show up in court every time. That goes in their favor. Financial considerations can be looked at and should. Linked in the community. Does that person have a job? Are they employed? The reason is because those are all criminogenic factors that can lead to whether or not someone is extremely dangerous or not. We know that if someone is unemployed, if they struggle with severe mental health issues, if they have family members and specifically parents who have been incarcerated or currently incarcerated, if they're struggling with addiction that has not been addressed, there are multiple different factors that they can look at. And oh, by the way, it's not just about the amount of bond. It's about the conditions of bond. Is it a domestic assault or an aggravated domestic assault? Is it a rape where the conditions of bond should say you're not in the conditions of bond can say stay away from that person. So when you're looking at ability to pay, and that's the only thing you're looking at, you're ignoring the entire rest of the statute to the detriment of a community that had 399 people killed last year. To your original question, it is absolutely not working. There is blood running in the streets of Memphis today because they're letting people out that should have a bond and conditions.
Balcony, this is your one warning. The next outburst, you are gone. I would refrain from talking. Representative from back in the corner, you cannot address without being recognized, please. Representative Ritchie, you're recognized.
Thank you, Mr. Speaker. Move previous question.
Previous question being called. There's objection. We're voting on previous question. He rolled one spot. All those in favor of previous question, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 73, 22 nays.
Senate Bill 25-6. Oh, previous question prevails. We are voting. All those in favor of Senate Bill 2565 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk. Mr. Clerk, please take the vote.
Aye, 74, 20 nays, 2 present, not voting.
Senate Bill 2565 having received the constitutional majority, everybody declare passed without objection. Most reconsider is taken. Call the next bill, Mr. Clerk.
House Bill 282 by Representative Baum, relative to practice of pharmacy. Mr. Speaker, the Senate bill is on the desk.
Representative Baum, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 869.
Representative Baum moves substituting form Senate Bill 869, probably seconded without objection. So ordered. Representative Baum.
Thank you, Mr. Speaker. I move passage of Senate Bill 869 on third and final consideration.
Representative Bond moves passage of Senate Bill 869 on third and final consideration. Properly second, Mr. Clerk, call First Amendment.
House Health Committee Amendment number 1.
Vice Chairman Leatherwood, you're recognized.
Thank you, Mr. Speaker. This amendment rewrites the bill. I move to adopt and defer to the sponsor for further explanation.
Vice Chairman Leatherwood moves adoption. Committee Amendment number 1, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of adopting Amendment number 1 say aye, aye. All those opposed say no. The ayes have it. You adopt the next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Helton Haynes, for what purpose?
Thank you, Mr. Speaker. I would like to introduce the doctor of the day from Hamilton County. His name is Dr. Brian Bingham. He is a radiologist, oncologist. Please make him welcome. Thank you, Mr. Speaker.
Representative Baum, you're recognized.
Thank you, Mr. Speaker. 90% of Tennesseans live within 5 miles of a pharmacy. This is a bill that will increase access to health care and provide health care at lower costs by permitting pharmacists to prescribe and dispense medicines and tests in 8 new categories. These categories have been agreed to by the Tennessee Pharmacy Association and the Tennessee Medical Association. And I probably should add that some of the items in these categories, pharmacists temporarily have the ability to prescribe and dispense medicines for. Under the Federal PrEP Act, that act will sunset at the end of 2024, and this will allow pharmacists to continue providing services in those areas. This will increase access to health care for your constituents. Mr. Speaker, I will renew my motion.
Representative Baum renews his motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor, Senate Bill 869 is amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 93, 3 nays.
Senate Bill 869 has received constitutional majority. Everybody clerk pass without objection. Most read Sarah's table. Call the next bill, Mr. Clerk.
House Bill 2269 by Chairman Boyd relative to Health Facilities Commission.
Chairman Boyd, you're recognized.
Thank you, Mr. Speaker. I would like to roll House Bill 2269 to directly behind item number 38 on today's calendar, Mr. Speaker.
Without objection, roll. Representative Doggett, for what purpose?
Thank you, Mr. Speaker. I'm probably out of order, but members I have with me today from the UT Southern College here, the Ingram Scholars Group that are visiting with us. They're up in the balcony to our right, so please help me welcome them to the floor today.
Chairman Boyd, call the next bill, Mr. Clerk.
House Bill 2625 by Chairman Boyd relative to accreditation. Mr. Speaker, the Senate bill is on the desk.
Chairman Boyd, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2528.
Chairman Boyd moves substitute and conform Senate Bill 2528. Probably second without objection. So ordered. Chairman Boyd.
Thank you, Mr. Speaker. I move passage of Senate Bill 2528 on third and final consideration.
Chairman Boyd moves passage of Senate Bill 2528 on third and final consideration. Probably second. Mr. Clerk, call First Amendment.
House Education Administration Committee Amendment number 1, same as Senate Amendment number 1.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Same as the Senate amendment, so I move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Government Operations Committee Amendment number 1, filed as House Amendment 2.
Chairman Reagan, you're recognized.
Thank you, Mr. Speaker. This amendment makes technical corrections which are not in the Senate version. Move to adopt and defer to the sponsor for explanation.
Chairman Reagan moves adoption of committee amendment number 2. Probably second. Any discussion on the amendment? Seeing none. All those in favor of committee amendment number 2 say aye, aye. All those opposed say no. The ayes have it. You adopt the next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Boyd, you're recognized.
Thank you, Mr. Speaker. Members, a few years ago, the federal government made some rule changes that allow institutions of higher learning around the country to use a different accrediting agency than the one that is geographically associated with them. This simply puts that into state law and clarifies that whatever accrediting agency they use has to be recognized by the database created by the federal government. It also specifies that the accrediting agency shall not compel a public institution of higher learning to violate a state law. And if they attempt to do that, it creates a private right of action. Thank you, Mr. Speaker. I renew my motion.
Chairman Boyd renews his motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker and sponsor. Overall, I appreciated that this was expanding the amount of people or entities that could provide some form of accreditation, but I was concerned when it says only to the extent that state law is not preempted by federal law, recognizing the necessity of the accreditation standard or requirement. So an agency, and I think the intention of your legislation is that an agency, particularly outside of our state, couldn't come to one of the universities and say, you need to fix this problem. And the problem that they're being asked to fix is something that we have passed in this body that could impact their accreditation, if I'm kind of understanding the general principles of what you're seeking to do. But if there are the narrowness of federal law, if there are policies or other things that are necessary for universities to be able to get accreditation, and those are seemingly contrary to state law, what are they supposed to do in those instances? It's not a federal law, but it is a part of the way that an institution gets its accreditation. And a lot of agencies or organizations that would be doing this work have rules that are being promulgated from maybe a federal law, but it isn't explicitly written in there. So what are they supposed to do?
Chairman Boyd.
Thank you, Mr. Speaker. So to the first part of what you said, I think you're spot on. I think your understanding of the bill is exactly the intent. The second part of your question, if there is a conflict, if the accrediting agency is asking them to do one thing and the state of Tennessee or the federal government is asking them to do something else, they will have to comply with the state or the federal law that has jurisdiction. And if the accredited agency doesn't back off, then it does create a private right of action. They can sue them civilly.
Representative Pearson.
Thank you, Speaker and Sponsor. Thank you for answering the question. I think my challenge still is, if it isn't necessarily a federal law, but there's a policy that's being required for the accreditation of higher education, right? And that policy is what this accreditor is saying you're out of step with. Does that have more power than, say, a state law that they're seeking to implement? Or are you saying it explicitly must be a federal law?
Chairman Boyd.
Thank you, Mr. Speaker. Make sure I understand what you're saying. So if the institution of higher learning has to decide between following a state law or breaking state law to gain the approval of the accrediting agency, they will have to follow state law, and the accrediting agency will have to back off. If they don't, then they can be sued by that institution.
Representative Pearson.
Yeah, we're introducing a serious tension, I think, here, because if their accreditation, right, and the standards by which it exists come from or stem from rules promulgated through federal law. It's not a federal law, but these are rules that have been given, or powers that have been given to these accreditors for our higher education institutions nationally. You're saying, even though those rules exist because they started off, right, with the federal law that said these are the rules that are going to be implemented, but they're not explicitly written, that our higher education institutions could lose their accreditation. They could also sue, but they could lose their accreditation because they're not following sort of the rules that have been promulgated for higher education. And so if they lose their accreditation, what remedy do they have outside of the court? Because that wouldn't change the ramifications to their academic curriculum. That wouldn't change the ramifications to people who now are graduating from an institution that no longer has accreditation. It is the only thing, sort of the civil ability, the ability to go before a court, but that wouldn't change sort of the real academic effects for the students.
Chairman Boyd.
Thank you, Mr. Speaker. That was a long question, and I guess the bill is pretty straightforward. We don't know that there's going to be any sort of conflict between one of the accredited agencies and state or federal government. But if there is, we're getting ahead of this. I mean, we've seen some non-governmental entities like the NCAA that have taken action against the University of Tennessee on a state law that we passed, the NIL law. And this is just kind of doing the same thing over in the accrediting world as well. So it's pretty cut and dried. I mean, the accrediting agency shall not compel an institution of higher learning in the state of Tennessee to violate state law. And if they do, they're going to be sued. I mean, it's really that easy.
Representative Williams.
Question on the bill.
Question's been called. Any objection? Seeing none, we're voting. All those in favor of Senate Bill 2528 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 81, 11 nays.
Senate Bill 2528 having received a constitutional majority, I hereby declare passed without objection. Motion reconsidered table. Call up next bill, Mr. Clerk.
House Bill 2376 by Representative Butler, relative to health care. Mr. Speaker, the Senate bill is on the desk.
Representative Butler, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2299.
Representative Butler moves substitute form Senate Bill 2299, probably seconded without objection. So ordered. Representative Butler.
Thank you, Mr. Speaker. I move passage of Senate Bill 2299 on third and final consideration.
Representative Butler moves passage of Senate Bill 2299 on third and final consideration, probably seconded. Ms. Clerk, call up First Amendment.
House Health Committee Amendment number 1 is same as Senate Amendment number 1.
Vice Chairman Leatherwood, you are recognized.
Thank you, Mr. Speaker. This amendment is the same as the Senate amendment. I move to withdraw.
Without objection, Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Butler, you're recognized.
Thank you, Mr. Speaker. This piece of legislation just clarifies some codes for home health care organizations. And with that, Mr. Speaker, I renew my motion.
Representative Butler renews his motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, all those in favor of Senate Bill 2299, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 93, no nays, 1 present, not voting.
Senate Bill 2299 having received a constitutional majority, I hereby declare passed without objection. Motion reconsidered table. Call up next bill, Mr. Clerk.
House Bill 2368 by Chairman Carr and others relative to residential infrastructure development districts. Mr. Speaker, the Senate bill is on the desk.
Chairman Carr, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2315.
Chairman Carr moves substitute and conform Senate Bill 2315, probably seconded without objection. So ordered. Chairman Carr.
Thank you, Mr. Speaker. I move passage of Senate Bill 2315 on third and final consideration.
Chairman Carr moves passage of Senate Bill 2315 on third and final consideration. Probably second. Ms. Clerk, call First Amendment.
House Local Government Committee Amendment number 1. Mr. Speaker, it's the same as Senate Amendment number 1.
Chairman Crawford, you are recognized.
Thank you, Mr. Speaker. Same as Amendment 1 in the Senate. Move to withdraw.
Without objection, Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Finance Ways and Means Committee Amendment number 1 filed as House Amendment 2.
Chairlady Hazelwood, you're recognized.
Thank you, Mr. Speaker. Move to adopt and defer to the sponsor for an explanation.
Chairlady Hazelwood moves adoption. Committee Amendment number 2, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of Amendment number 2 say aye, aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Carr, you're recognized.
Thank you, Mr. Speaker. All this bill does, it's the, I gotta say it right, RIDA bill. It allows for a developer, if he goes to develop a property, for him to make come in consideration with the Industrial Development Board, and they can bond all his infrastructure and give him the money for the infrastructure, and that way he can go ahead and start building. These bonds and everything are insured and underwritten, and therefore if the Industrial Development Board or the developer goes bankrupt, then they'll all be paid for by the bonding company, or by the underwriter. And with that, I renew my motion.
Representative Carr renews his motion. Any discussion on the bill? Representative Wright.
Thank you, Mr. Speaker. Move previous question.
Previous question been called. Is there objection? Seeing none. All those in favor of Senate Bill 2315 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 94, no nays.
Senate Bill 2315 having received constitutional majority, everybody clerk passed without objection. Most reconsidered table. Call next bill, Mr. Clerk.
House Bill 2686 by Chairman Doggett relative to expunction. Mr. Speaker, the Senate bill is on the desk.
Chairman Doggett, you are recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2844.
Chairman Doggett moves substitute and form Senate Bill 2844, probably seconded without objection. So ordered. Chairman Doggett.
Thank you, Mr. Speaker. I move passage of Senate Bill 2844 on third and final consideration.
Chairman Doggett moves passage of Senate Bill 2844 on third and final consideration, probably seconded. Mr. Clerk, call First Amendment.
House Criminal Justice Committee Amendment number 1, same as Senate Amendment number 1.
Chairman Holsey, you're recognized.
Thank you, Mr. Speaker. Same as Senate Amendment number 1. Move to withdraw.
Without objection, Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Finance Ways and Means Committee Amendment number 1 filed as House Amendment 2.
Chairlady Hazelwood, you are recognized.
Thank you, Mr. Speaker. I move to adopt and I defer to the sponsor for an explanation.
Chairlady Hazel moves adoption of committee amendment number 2, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of committee amendment number 2 say aye. Aye. All those opposed say no. The ayes have it. You adopted the next amendment,
Mr. Speaker, no further amendments.
Chairman Doggett, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, a few years ago, we made some changes in the code in regards to expungement. And what this bill seeks to do is to come back and clarify that you're only eligible for one expungement under G, K, or M. And with that, I renew my motion.
Chairman Doggett renews his motion. Any discussion on the bill? Representative McCallum.
Thank you, Speaker. Move previous question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 2844 as amended vote aye when the bell rings. Those opposed vote no. As every member voted, does any member wish to change their vote? Mr. Clerk. Mr. Clerk, please take the vote.
Ayes 92 nays.
Senate Bill 2844 having received constitutional majority, I hereby declare passed by objection. Most reconsider table. Call the next bill, Mr. Clerk.
House Bill 2118 by Representative Fritz, relative to energy policy.
Representative Fritz, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 2118 on third and final consideration.
Representative Fritz moves passage. Following second, Ms. Clerk, call it first amendment.
House Agricultural and Natural Resources Committee Amendment number 1.
Chairman Todd, you are recognized.
Thank you, Mr. Speaker. I move to roll this to the heel of the amendments.
Without objection, roll to the hill. Next amendment, Mr. Clerk.
House Government Operations Committee Amendment number 1 filed as House Amendment 2.
Chairman Reagan, you are recognized.
Thank you, Mr. Speaker. This amendment makes the bill. I defer to the sponsor for further explanation and move to adopt.
Chairman Reagan moves adoption of committee amendment number 2. Probably seconded. Any discussion on the amendment? Seeing none. All those in favor of committee amendment number 2 say aye. Aye. All those opposed say no. The ayes have it. You adopt the next amendment, Mr. Clerk.
Mr. Speaker, that brings us back to the House Agricultural and Natural Resources Committee.
Chairman Todd, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Fritz, you're recognized.
Thank you, Mr. Speaker. This bill simply is a restructure of the State Energy Policy Advisory Council. It does so to position our state with the correct subject matter expertise on that council to transition us into a stronger base of nuclear power and provide a bridge to get us there. It hybrids its approach with the governor's Executive Order 101 for last year. And with that, Mr. Speaker, I renew my motion.
Representative Fritz renews his motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker. And sponsor, based on what I saw here, there are only a select few counties that were chosen to be a part of this, including Hamilton, Anderson. But Shelby County is not included in there. And so I was curious sort of why that decision was made. And also you have the Tennessee Valley Authority having a representative. And Shelby County is actually Tennessee Valley Authority's largest customer. And so just wanted some elaboration.
Representative Fritz.
Thank you, Mr. Speaker. Thank you for the question. Very simply, if you look at the geography of those counties that are called out specifically, they have a strong nuclear base in those areas around Chattanooga, up into Unicoi County, and certainly Roane and Anderson County around Oak Ridge. I would note, Representative, that we call out in this establishment of this Energy Policy Advisory Council also subject matter expertise on crude oil. Memphis has about 1% of the nation's crude oil refinery capacity. So there is a specific call out that I would think would probably draw expertise from that area.
Representative Pearson.
Thank you. Thank you for answering the questions, and thank you, Speaker. The only other thing I had with the Governor's Council, I guess, sunsetting, is that what's happening? And this would be reconstituting that? Is this in partnership with sort of the Governor's Council? Is this something that we are just creating sort of in and of ourselves?
Representative Fritz.
Thank you, Mr. Speaker. And as I said, it's a hybrid approach to what current code requires for State Energy Policy Advisory Council in Executive Order 101. That executive order is set to expire in November of this year, but this does not force that to go on. The governor could very well extend it, but it does combine those resources so that there's a standardized and uniform approach in deciding our energy policy for the state of Tennessee.
Representative Pearson.
Thank you, and I may have missed this when reading it. So the current board and this newly constructed board, which has representatives from the House and things like that, they're going to become one in November?
Representative Fritz.
Thank you, Mr. Speaker. Negative, that is not the case. There still will be a Governor's Executive Order 101 Nuclear Supply Chain Council. That's the one that's set to expire. What this simply does is hybridize some of those really good things that the Governor's Executive Order did with what current State Energy Policy Council is doing.
Representative Pearson.
Okay. Thank you, Speaker and sponsor.
Representative Hardaway.
Thank you, Speaker. And to the sponsor, when we talked about it in ag, you did express your intent that the state would be well represented by Grand Division or by the diversity, both of the economic impact that the different types of energy have on different areas. And we talked about Memphis and Shelby County and the expertise, not just in the refinery issue, but with the University of Memphis and their intellectual prowess. And I'll just ask you to restate those.
Representative Fritz.
Thank you, Mr. Speaker, and thank you for that question. So there are 225 roughly nuclear manufacturing facilities around the state of Tennessee today. 175 of those are in Knox or Anderson County area. And so you'll see some of the call outs in this bill to tailor the expertise so that we can get to that nuclear baseload future that we suspect is coming with the nuclear renaissance. But you will also see that there's a call out in that bill for academic expertise on energy production and transmission, and that certainly would open it up to any of the great universities in the great state of Tennessee.
Representative Hardaway. All right, any further discussion? Seeing none, any objections to the question? Seeing none, we're voting. All those in favor of House Bill 2118 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 80, 14 nays.
House Bill 2118 and received constitutional majority. I hereby declare passed without objection. Most reconsider taken. Call up next bill, Mr. Clerk.
House Bill 2190 by Representative Fritz relative to authority of the governor.
Representative Fritz, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 2190 on the third and final consideration.
Representative Fritz moves passage. Following second. Mr. Clerk, call up First Amendment.
House State Government Committee Amendment number 1.
Chairman Kiesling, you're recognized.
Thank you. Thank you, Mr. Speaker. We move to withdraw Amendment 1.
Without objection, Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Finance Ways and Means Committee Amendment number 1 filed as House Amendment 2.
Chair Lady Hazelwood, you're recognized.
Thank you, Mr. Speaker. I move to adopt and I defer to the sponsor for an explanation.
Chair Lady Hazelwood moves adoption of Committee Amendment number 2. Following second. Any discussion on the amendment? Seeing none. All those in favor of Committee number 2 say aye. Aye. All those opposed say no. The ayes have it. You adopt. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Fritz, you're recognized.
Thank you, Mr. Speaker. This bill Bill 2190 simply complies with Article 3, Section 5 of our Tennessee State Constitution, authorizing the governor to deploy force in case of an invasion, which has been declared, especially in Texas. And with that, I'd renew my motion.
Representative Fritz renews his motion. Any discussion on the bill? Representative Jones.
Thank you, Mr. Speaker. There's a saying, Representative Fritz, that says, Dime con quien andas y te diré quién eres. Show me who you're with. That shows me who you are. If you are using the same rhetoric as white nationalists, that perhaps shows us who we are in this body. It is white nationalists using these hateful terminologies like invasion. It is white nationalists using the same rhetoric that you use calling people illegal aliens. I mean, this is shameful, and this bill is unnecessary. It's a waste of taxpayer money. There's an estimated cost of $1.4 million for this fear-mongering.
Representative Jones, continue.
Y'all can boo, but I'm still going to talk. And so this bill is a waste of $1.4 million of taxpayer money to feed into the fear-mongering of the White Sheets caucus across the aisle. The caucus who continues to demonize immigrants. The caucus who continues to target.
Representative Spicky, you had a point of order. What was it? Please come forward. Representative Sapicki, you're recognized.
Thank you, Mr. Speaker. My point of order addresses a member on the House floor violating Rule 19, disparaging members of the floor. I would just ask the clerk or the speaker to take appropriate action.
So you're using Rule 19 to call that member that you said disparaged the body to order.
Correct. That is correct.
Mr. Clerk, would you like to? Mr. Clerk.
Mr. Speaker, the point of order was Chairman Sapicki raised a point of order that the member was out of order pursuant to Rule 19, and now I believe that he is seeking to make a motion based on that point of order.
Mr. Clerk. Mr. Clerk.
Mr. Speaker, there has been, Chairman Sapicki has called the member to order pursuant to Rule 19. At this point, the member could sit down and forfeit that time and we would move forward. Or if there's an appeal to that, then we would put it on the board and the body would determine whether or not the member shall continue.
Lambert. Leader Lambert.
Thank you, Mr. Speaker. Unfortunately, we're in a difficult situation here in which a member has impugned the entire body. And I don't know what all members he was referring to, but I would appeal to the body because his words were the white sheet caucus. That's not appropriate here. We're all colleagues elected by the same number of people. Flinging insults of that nature is just not appropriate. I would appeal to the body for a vote.
All right, we're on the board. Is it point of order or primary question? There's two differences. All right, we are voting. There was Rule 19 for disparaging comments. There was an appeal. We are on the board. All those in favor? All those in favor of the member continuing on the allotted time, vote aye. All those opposed to the member continuing, vote no. Mr. Clerk, take the vote. Mr. Clerk, take the vote.
Ayes 19, 73 nays.
Member does not continue. Representative Warner, you're recognized.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. There's objection. We're on the board. All those in favor of previous question, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 72, 24 nays.
Previous question for bells. We are voting. All those in favor of House Bill 2190 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Doggett, aye. Dixie, no. Mr. Clerk, please take the vote.
Ayes 71, 24 nays.
House Bill 2190, having received constitutional majority, I hereby declare passed without objection. Most reconsider table. Call up next bill, Mr. Clerk.
House Bill 2712 by Representative Garrett, relative to performance venues. Mr. Speaker, the Senate bill is on the desk.
Representative Garrett, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2508.
Representative Garrett moves substitute and conform to Senate Bill 2508, probably seconded without objection. So ordered. Representative Garrett.
Thank you, Mr. Speaker. I move passage of Senate Bill 2508 on third and final consideration.
Representative Garrett moves substitute and conform to Senate Bill 2508, properly seconded without objection. So, Representative Garrett moves passage of Senate Bill 2508 on third and final consideration, properly second. Mr. Clerk, call up First Amendment.
House Commerce Committee Amendment number 1.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. We're moving to withdraw.
Without objection, Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Government Operations Committee Amendment number 1, filed as House Amendment 2, same as Senate Amendment number 2.
Chairman Reagan, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 2 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Garrett, you're recognized.
Thank you, Mr. Speaker. Members, this bill establishes and defines, for the purposes of the state of Tennessee, of what is a small live performance music venue. Secondly, the most important piece, I believe, of this legislation is it creates a fund that will be administered by our Tennessee Consumer Protection Act, the Tennessee Community Development Board, on grants to secure and assist those venues in the state that perform live performances for small venues. The grant process is not designed for large venues like you would think of the Ascend, Bridgestone, the Titan Stadium for different concerts that come there. These are for our small venues that live performance perform in nightly or several times during the week. So with that, Mr. Speaker, I'll be happy to take any questions. Otherwise, I renew my motion.
Representative Garrett renews his motion. Any discussion on the bill? Representative Parkinson.
Thank you, Mr. Speaker. I'm glad you called on me first. Mr. Sponsor, can you define what a small venue performance hall is, please?
Representative Garrett, you're recognized.
Thank you for the question. Thank you, Mr. Speaker. It's actually in the piece of legislation defined in the legislation what a small venue is. So I would refer to the legislation unless you want me to read it. I'll be glad to do that. But the definition is in the particular piece of legislation how a small venue is defined.
Representative Parkinson. Representative Parkinson.
I'm reclaiming my 40 seconds because I couldn't hear the sponsor's response. And Mr. Sponsor, I'm sorry, I didn't, I don't know the details of your legislation because I didn't hear it. And the reason why I'm asking is because we got some venues in Memphis that are possibly excluded from stuff because of a contract with the FedEx Forum. So I want to see if this can help those venues, and I apologize for that.
Representative Garrett.
Thank you, Mr. Speaker. Without reading from the piece of legislation, I mean, under Section 3, it does define live music and performance venue, and it actually gets down to the details of how often they have performances, who's there, how it books it, that they are primarily for live performances only. And so it's designed to be for our small venues. So if it's got a connection or owned by something that is larger, like Live Nation or something like that, it would be my opinion, it would be my hope that the legislation is designed not for the big guys. This is designed for the small guys to make sure that in the COVID year, when things were shut down and there was no money helping these small venues, we're not asking for an appropriation yet to fund the grant program. That will come hopefully in the next legislative sessions, but this is designed for, I believe, the venues that you're having in mind in Memphis, and it also applies, of course, statewide.
Representative Parkinson.
Thank you, Mr. Speaker. Is there a capacity cap that you have in the legislation by chance?
Representative Garrett.
That's a good question. There is not a capacity cap because those details will be promulgated by the Government Ops Committee. Once ECD establishes those rules, we will be able to approve those next year when those rules go through the committee. And if there's not a capacity issue and that becomes one, that can be certainly part of the legislation that defines the parameters of the grant.
Representative Parkinson.
Thank you, Mr. Speaker. Thank you, Mr. Sponsor.
Representative Cochran.
Thank you, Mr. Speaker. And Representative Garrett, just one quick question. What would you envision maybe the grants being used for? I understand maybe some of those details will be worked out later, but if a venue were applying for this, maybe in your vision for the grander scheme of this, what would you envision?
Representative Garrett.
Thank you, Mr. Speaker. That's a great question, Leader Cochran. I appreciate that. My hope is, one, would be a marketing tool, right? That they can market for our small venues, that more people can come into that space and know we have that ability, that we're not just somewhat what you see on television, the Bridgestones, the Nissan, those type concert venues. It's very important to our small folks, small business folks, that we have the ability to market that. So that'd be one. Sometimes these dollars for these small venues, they don't have a marketing budget. There's no way for them to get the word out. And when we're promoting Tennessee, and Tennessee is so connected to the music industry, there's no mechanism right now with ECD to provide for this specific space that's so important to our thriving music industry. So this is something that the state can get behind to provide money for marketing dollars and other things that our small venues just don't have a budget for at the moment.
Representative Wright.
Thank you, Mr. Speaker. Move previous question.
Previous question being called. Is there objection? Seeing none. All those in favor of Senate Bill 2508, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 88, 4 nays, 1 present, not voting.
Senate Bill 2508, having received constitutional majority, everybody clerk pass without objection. Most weeks here stable. Call up next bill. Mr. Clerk, hang on. Leader Lambert, you're recognized. Sorry.
Thank you, Mr. Speaker. I move to take up item number 38, House Bill 474 at this time.
Without objection, so ordered. Mr. Clerk, call up next bill. Call up next bill, Mr. Clerk.
Mr. Speaker, pursuant to the motion made, we're on item 38, House Bill 474 by Chairman Reagan relative to local governments. Mr. Speaker, the Senate bill is on the desk. Mr. Speaker, members, pursuant to Rule 49, there has been a 50-minute time limit on debate established for this bill. The time will be evenly divided between the two caucuses. The sponsor will have 5 minutes to present the bill and 2 minutes to close pursuant to the rule. Any time consumed by the sponsor in answering questions is taken out of the time allotted to the asking member. The sponsor will not be allotted any additional time between members recognized on the floor unless time is yielded by the leader of the sponsors caucus.
Chairman Reagan, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 429.
Chairman Reagan moves substitute and conform Senate Bill 429, probably seconded without objection. So ordered. Chairman Reagan.
Thank you, Mr. Speaker. I move passage of Senate Bill 429 on third and final consideration.
Chairman Reagan moves passage of Senate Bill 429 on third and final consideration. Probably second. Mr. Clerk, call First Amendment.
House Local Government Committee Amendment number 1, same as Senate Amendment number 1.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. Same as Senate Amendment 1, move to withdraw.
Without objection, Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Local Government Committee Amendment number 2.
Chairman Crawford, you are recognized.
Thank you, Mr. Speaker. I move to adopt and defer to the sponsor for further explanation.
Chairman Crawford moves adoption of committee amendment number 2, probably seconded. Any discussion on the amendment? Seeing none, all those in favor of committee amendment number 2 say aye. Aye. All those opposed say no. The ayes have it. You adopt. Next amendment, Mr. Clerk.
House Amendment 3 by Representative Miller, Mr. Speaker, was timely filed.
Representative Miller, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, Chairman Reagan, I was hoping that we wouldn't see the light of day on this bill, but it's unfortunate that it's back with us. This amendment, Chairman Reagan, is Anderson County, is that part of your district?
Sir, this is your amendment, so we're dealing with your amendment. This is you, the sponsor of your amendment. Representative Miller, you're recognized.
Anderson County, part of your district. This amendment simply says that giving your county permissive legislation to consider studying reparations. And the reason for that amendment and the reason that it's permissive, it takes it back to your county, your constituents, because I'm assuming that the reason you have this legislation is because your community, your city, your county has asked you to bring this bill to this floor. About 2/3 majority vote in your county, they can decide if they want to study, get a learning understanding of what reparation is really about. They have the ability to do that. Your local government making that decision. Because what your bill is actually saying that no monies can be expended to study or distribute any funding. I can better understand that if it was state funding. But your local government, I'm assuming, pay property taxes, they pay sales taxes, and those are local government dollars. Give your county an opportunity to talk about this. Because I do support local government, especially when legislation deals with what's permissive. And with that, I move for adoption.
Representative Miller moves adoption of amendment number 3, properly seconded. Any discussion on the amendment? Chairman Reagan.
Thank you, Mr. Speaker. I view the amendment as hostile and I move it to the table.
Proper motion, probably second, parliamentary situation. Representative Miller has moved adoption of amendment number 3. Representative Reagan has moved that motion to the table. It cuts off all debate except for that sponsor. Representative Miller, you are recognized.
Chairman Reagan, to move it to the table with a comment prior to that, that it is hostile. I'll show you my intention is not to be hostile with you or this bill. I'm just simply trying to prove a point. The timing of your legislation is bad. It's not good for this General Assembly. It's not good for this community. The only thing it does is to further divide us, further divide us. The idea of studying reparation doesn't hurt you. It doesn't take anything from you. So why do you continue to make it seem that way? What's inside of you to make you want to further say, look, you can't study our history. You can't even talk about our history. You can't even spend your local tax dollars to talk about it, to study it. That is so antiquated. That if anything is foreign, this is one thing that's foreign in thinking and thought, in being rational, in being passionate, in being understanding. This bill says nothing about that. In other words, it's a cruel intent, in my opinion, to say to people in this state, especially African American people in this state, we don't want to talk about this anymore. I don't even want to learn anything about this anymore. That's why this particular amendment simply says, let your people in your district talk about it and study it. Well, they have the option to do that one way or the other. Take it before your legislative body, your local body. Let them decide by 2/3 votes, we don't want to study it, we don't want to talk about it. But leave the rest of us alone. Let us do it locally if we want to do that. If in fact I want to spend my sales tax dollars and or my property tax dollars with my local county commission to study. Back in the day in history, it was illegal for Black folk to even think about learning how to read. It was illegal. And today you bring this antiquated thinking to this body to say to anyone, local government to individuals, you cannot and you should not study reparations. It's ugly. For lack of a better word, it's ugly. It's bad. I ask you to vote for this amendment.
Parliamentary Situations, Representative Miller has moved adoption of Amendment Number 3. Representative Reagan has moved that motion to the table. We're voting on the tabling motion. All those in favor, vote aye of tabling. Vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 68, 25 nays.
The ayes have it. The motion to adopt Amendment Number 3 is tabled. Call up next amendment, Mr. Clerk.
House Amendment 4 by Representative Miller. Mr. Speaker, it was timely filed.
Representative Miller, you're recognized.
Thank you, Mr. Speaker. Chairman Reagan and to the members of the body, this amendment will somewhat give us a way out of actually not passing this bill. It creates a task or study on the concept of reparation. The study must review the positive and negative outcomes that may be caused by reparation programs. The report must be submitted to members of the General Assembly on or before December 31st, 2024. TASER one of our most premier intergovernmental agencies. They do a great job. Bipartisan body, agency, with some of the most intelligent individuals to do studies that we request them to do from time to time. This amendment simply says, let them study the concept and the idea of reparation. They will give us some type of historical perspective. When did it start? What does it mean? A more comprehensive understanding, Chairman Reagan, of what it is, what it means, what are the pros and cons of it. That shouldn't hurt you. That shouldn't offend you. Why would you not want that, Chairman Reagan? With that, I move for the adoption of amendment number 3.
4.
4.
Representative Miller moves adoption of amendment number 4, properly seconded. Any discussion on the amendment? Leader Lambert, you're recognized.
Previous question on the amendment.
Question's being called on the amendment. Any objection? Seeing none. All those in favor of amendment number 4, vote aye when the bell rings. Those opposed, vote no. Mr. Clerk, has every member voted? Does any member wish to change their vote? Grills, no. Grills is no. Mr. Clerk, take the vote.
Ayes 25, 69 nays.
Amendment number 4 fails. Next amendment, Mr. Clerk.
House Amendment 5 by Representative Miller. Mr. Speaker, it was timely filed.
Representative Miller, you recognize.
Thank you, Mr. Speaker. You know, it's unfortunate that the last amendment actually failed. That was an opportunity, as I said, to find a way out of having to even talk about it, to vote on this bill. But this amendment is giving it back to local government to make a decision, 2/3 votes in your municipalities. If they want to talk about it, to study it, if they don't have to, if they don't want to, then they'll vote. They are conscious about it. With that, I move for amendment, adoption of the amendment.
Representative Miller moves adoption of amendment number 5, properly seconded. Any discussion on the amendment? Chairman Reagan.
Thank you, Mr. Chair. I ask my fellow members of this body to vote against it.
Leader Lambert.
Previous question on the amendment.
Previous question's been called. Any objection? We're voting. All those in favor of adopting amendment number 5, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 25, 68 nays.
Amendment number 5 fails. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Reagan, you're recognized.
Thank you, Mr. Speaker. This bill prohibits local governments from expending taxpayer funds to study or disperse reparations to the descendants of slaves. Unfortunately, municipalities in our state have already actively contemplated such programs without any sound constitutional grounds or uncontestable legal authority to do so. Despite any good intentions of such actions, they have not fostered and can never enhance community healing and unity. Rather, the real impact divides us and generates more bitterness. Ill-founded accusations of collective guilt and group punishment for wrongs no one in the group could have ever committed creates resentment always. All of the evils that humans perpetrate against each other, slavery is among the most unconscionable. There can never be a morally appropriate reason for for unjustly depriving a person of their God-given liberty and selling them into servitude. This is true whether the enslaver is an African monarchy or a Mexican cartel. It is also true whether the transaction It is also true whether
hang on, Chairman. Yeah, come on up. Parliamentary question. Mr. Clerk.
Let's see. Mr. Speaker, the point of order raised by Representative McKenzie raised a point of order stating that the member was off topic of the bill, and I believe Representative McKenzie has a motion based on that.
Representative McKenzie.
Thank you, Mr. Speaker. As we discussed, the sponsor of this bill, in his ignorance as to what the bill says, that is not a point of order.
Yes, it
I
is.
am on.
That's a point of order. No, sorry. Sorry. Yeah. Representative McKenzie.
Thank you, Mr. Speaker. My point of order against what the sponsor was espousing during his 5-minute interlude was simply dealing with the fact we're talking about no community, municipality being able to study reparations. And within that bill, and as he talked about earlier, he's talking about slaves and descendants of slaves. But then he got way off topic and started speaking on Mexican cartels and human trafficking, blending that together for whatever reason. Totally off topic of the bill. He was unaware that, my contention is that he was unaware as to what the topic of the bill was and ventured way off course. So as it relates to Rule 18, he did not stay on the bill. So I'm asking that you rule him out of order via Rule 19.
Yeah, you've ruled him to order under Rule 19. That's what you have done, Representative. And I believe we're moving off the 5 minutes. So there we go. Representative Reagan, your turn. You yield your 5 minutes? He yields his 5 minutes. There we go. Representative Parkinson, you're recognized. Representative McKenzie?
I don't want to come back up to the well, but I guess what I'm asking is, where are we situated with my position?
You have ruled him to order. The usual thing is they agreed to stop talking, and that satisfies your rule to order. And then the next one we're dealing with is Representative Parkinson. Representative Parkinson.
Thank you, Mr. Speaker. And does the clerk not explain it, or do I explain it? How does this work?
You're the one making the motion.
Thank you, Mr. Speaker. Mr. Speaker, my objection to the member was his inference of African monarchs as if slavery in America, Africans were responsible for it. And that's totally incorrect. It's inferring that the kidnapping, the forced rape of men, women, and children, the forced labor, in some cases to death, the whippings, beatings, dismemberment of African slaves in America was partially responsible by Africans. But where the member is wrong is that that was part of the exploitation of African people that brought this horrible experience to these shores. I find it very audacious that the member would even mention that in his preamble to presenting his legislation. And it's mean-spirited, and it's insulting, and I want to call to order the member because he is way off base when it comes to us simply discussing the study of reparations for Africans, and it also impugns an entire race of people because there was no shipping across the Atlantic of slaves until the Europeans went to Africa at the behest sometimes of their government entities and privateers to exploit Africans on the continent of Africa and cruelly for 400 years bring them back to America only to be mistreated and not even be able to study what reparations is due to them. That is my point of order, Mr. Speaker.
So Representative Parkinson has called him to order as well. Yes, sir.
Object.
Can you? Okay, you object. We got it. All right. Representative Williams, you're recognized.
As much as I hate to ask, I'd like a parliamentary inquiry, please.
All right, come on up. Mr. Clerk.
Mr. Speaker, the parliamentary inquiry was under the rules of, first of all, do a violation of rules of decorum fall under Rule 19? Rule 19 says in speaking or otherwise transgresses the rules of the House. So yes, they do. Do rules of decorum and avoiding all personalities only apply when a member is recognized on the mic, or can a member's reputation be impugned personally by shouting across the House floor or otherwise? The answer is yes. That is a break of decorum in how you're treating and challenging a member's reputation.
We're on discussion of the bill. Leader Camper. Oh. Representative Williams, you're recognized.
Thank you, Mr. Speaker. I make a motion to roll this bill 3 spaces.
Without objection, roll 3 spaces. Call the next bill, Mr. Clerk.
Mr. Speaker, that brings the body back to item 15. Item 15 on the regular calendar, House Bill 2008 by Chairman Haston, relative to forms of payment accepted at school sporting events. Mr. Speaker, the Senate bill is on the desk.
Chairman Haston, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1998.
Chairman Haston moves to substitute and conform to Senate Bill 1998. Probably second without objection. So ordered. Chairman Haston, you're recognized.
Thank you, Mr. Speaker. I move passage of Senate Bill 1998 on third and final consideration.
Chairman Haston moves passage of Senate Bill 1998 on third and final consideration. Probably second. Mr. Clerk, call First Amendment.
House Education Administration Committee Amendment number 1, same as Senate Amendment number 1.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Same as the Senate amendment. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Haston, you're recognized.
Thank you, Mr. Speaker. We are seeing a growing number of public schools go cashless at their school sporting events. This bill will protect students who don't have access to a credit card or debit card or have a phone with a cashless payment app, requiring schools to offer students the ability to buy tickets with cash either at the event or in advance. With that, I renew my motion.
Chairman Haston renews his motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker and sponsor. The one concern that I have here is in a situation where you have a lot of cash at concession stands or things like that, the possibility of people potentially robbing or taking the money. And the reality is for a lot of younger people, using Cash App and buying Amazon and all these things is something that's extremely prevalent. And so could you just articulate where you're seeing this as a potential problem? Because for the majority of things, the expenses are happening online or using people's phone. And so I appreciate the idea of people having to have cash, but it's also a reality that that can increase some of the worries or concerns that we have as well.
Chairman Haston.
Thank you. That's why that this bill is permissive. School system wants to go cashless, they can.
Representative Pearson.
Okay, thank you, Speaker and sponsor.
Representative Halsey.
Thank you, Mr. Speaker. Just want to say I've tried 2 years to get that across the finish line. I hope you're successful. It does say on every piece of cash in the United States, legal tender for all debts, public and private. Thank you.
Chairman Haston.
Thank you. I would be remiss not to mention, some of y'all may have known Jeff Parrish. He was a constituent of mine that worked for Senator Blackburn's office that passed away a couple of months ago. This was the one and only bill that he had ever asked me to try to carry for him. And just wanted to say that I appreciated him bringing this good piece of legislation to me, and I appreciated his service for the state of Tennessee. Thank you. I renew my motion.
Chairman Haston renews his motion. Any discussion on the bill? Seeing none, we're voting. All those in favor of Senate Bill 1998, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Camper, aye. Mr. Clerk, please take the vote.
Ayes 96, no nays.
Senate Bill 1998, having received constitutional majority, I hereby declare passed without motion to reconsider its table. Call next bill, Mr. Clerk.
House Bill 2285 by Chairman Haston relative to temporary teaching permits. Mr. Speaker, the Senate bill is on the desk.
Chairman Haston, you recognize.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2674.
Chairman Haston moves to substitute and conform Senate Bill 2674, probably second without objection. So ordered. Chairman Haston.
Thank you, Mr. Speaker. I move passage of Senate Bill 2674 on third and final consideration.
Chairman Haston moves passage of Senate Bill 2674 on third and final consideration. Probably second. Mr. Clerk, call First Amendment.
House Education Administration Committee Amendment number 1.
Chairman White, you're recognized.
Thank you, Mr. Speaker. This is not in the Senate bill, so I move to adopt.
Chairman White moves adoption. Committee Amendment number 1, properly seconded. Any discussion on amendment? Seeing none. All those in favor of adopting Committee Amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
Mr. Speaker, we have Amendment 2 by Representative Powell. Mr. Speaker, it was not timely filed.
Representative Powell, you're recognized.
Thank you, Mr. Speaker. And I spoke to the sponsor about this amendment. So this bill, as you know, deals with the issuing of a temporary teaching license. And I think it's very important for the commissioner who has to make that determination to also have a teaching license. And so right now, we have a commissioner without a teaching license. So my amendment says that the commissioner must have a valid teaching license to consider the information in this section. Why is this important? Under TCA 4-3-802, which deals with the commissioner qualifications for appointment, section B, it says the commissioner shall also be qualified to teach in the school of the highest standing over which the commissioner has authority. With that, I move for consideration.
You've heard the motion, properly seconded. We are voting for consideration of amendment number 2. All those in favor of considering amendment number 2, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 26, 63 nays, 1 present, not voting.
In accordance with Rule 60B, having failed to receive necessary 2/3 vote, the motion to consider amendment number 2 fails. Next amendment, Mr. Clerk.
Amendment 3 by Representative Powell, Mr. Speaker, was not timely filed.
Representative Powell, you recognize.
All right, so let's take another bite at the apple. This amendment is slightly different. It says the commissioner must have a valid teaching license to determine whether to issue a temporary teaching permit. How can we expect to have a commissioner that doesn't have a teaching license to be the one who decides whether or not to issue a temporary teaching license when the commissioner herself does not have a valid teaching license. I mean, this is hypocritical to have somebody to have this decision and this authority, and they themselves do not meet the requirements in TCA. I don't know if the governor took a look at our TCA, but for 100 years now, we've required and had a commissioner of education with a valid teaching license. So I would ask and move for consideration of my amendment.
You've heard the motion, probably seconded. We're voting for consideration of amendment number 3. All those in favor of considering amendment number 3, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 26, 66 nays, 1 present, not voting.
In accordance with Rule 60B, having failed to receive necessary 2/3 vote, the motion to consider amendment number 3 fails. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Hastings, you're recognized.
Thank you, Mr. Speaker. This bill would allow the granting of a temporary teaching permit for courses requiring an end-of-course examination. This bill ensures that these temporary teaching permits are only applied for and granted as a last resort when filling vacancies. With that, I renew my motion.
Chairman Hastings renews his motion. Any discussion on the bill? Representative Pearson.
Thank you. Just an inquiry due to these amendments. Ultimately, would the authority lie with the Commission of Education to approve these temporary teaching licenses?
Chairman Hastings.
That is correct.
Representative Pearson.
Thank you. And do we know whether or not the Commission of Education has a teacher's license herself?
Chairman Hastings.
I think we know that.
Representative Pearson.
We know that she does not, or we know that she does?
Chairman Hastings.
I think that we know that she doesn't.
Representative Pearson.
Okay. Do you think that it is in any way concerning that she, who does not and has not gone through the process of licensure, would have a say-so over the licensure of these types of teachers?
Chairman Hastings.
I don't believe that that's on this bill. Be glad to try to address that later on if you have a bill that comes into the well.
Representative Pearson.
Thank you. I do believe it is concerning that the qualifications for our Commission of Education have not been met, and thus is promulgating rules necessary for people to actually teach inside of our classrooms. And one can definitely surround themselves with smarter people than themselves to make good decisions, and I can understand that. But empowering someone who doesn't meet that qualification themselves is quite troubling and challenging to me, particularly because we're talking about people going into our school system, working with our children. The person making that decision should have and be rooted more in the education system itself and have the capability to teach those very classes that they're now going to be, passing this licensure for. But I appreciate you answering the questions, sponsor, and thank you, Speaker.
Chairman Hastings.
And really, it's not necessarily the decision at the end of the line that's really going to be a reflection of this necessity. It's going to be at the local level. It would start off with the director of schools notifying the school board that the LEA is unable to secure a qualified teacher with a valid license for that course. So in essence, we're really trusting our locals to make the correct decision on this and even asking for the permission of it.
Representative Pearson.
Yep. Thank you for that answer, sponsor and Speaker.
Speaker Pro Tem Marsh.
Thank you, Mr. Speaker. Call question.
Question been called. Is there objection? There's objection. We're on the board. All those in favor of previous question vote aye when the bell rings. Those opposed vote no. As every member voted, as every member change vote. Mr. Clerk, please take the vote.
Ayes 74, 22 nays.
Previous question prevails. We are voting. All those in favor of Senate Bill 2674 as amended vote aye when the bell rings. Those opposed vote no. As every member voted, as every member must change their vote. Mr. Clerk, please take the vote.
Aye, 78, 19 nays.
Senate Bill 2674 having received a constitutional majority, I hereby declare passed without objection. Most reconsider is tabled. Leader Lambert.
Thank you, Mr. Speaker. We have quite a few bills left on the calendar today. I think about 30-something. I would make a motion that we recess at this point until 5:30 p.m. today.
It's proper motion, probably second. Any objection? Seeing we're recessed till 5:30.